Welcome to the Network for Public Health Law webinar, Reproductive Healthcare, Anticipated Changes and Potential Impacts under the New Administration. I am Kayleen Clarich, Associate Director of Communications at the Network. A couple of housekeeping notes before we start. The slides and a recording of today's webinar will be available within the next few days, and you will receive an email notifying you when they have been posted to our website. We invite you to use the Q&A function throughout the webinar if you have questions, and we will try to get to as many of your questions as possible. You do have the option to send your question anonymously if you prefer. If we are unable to address your questions today, or if you have a question on other public health issues, network attorneys are available to consult with you at no charge. You can request assistance directly on the network's website. With that, I will hand it off to Ashley Dennis, who will serve as the moderator for today's webinar. Ashley?
Thanks, Kayleen. Hi, everybody. My name is Ashley Dennis. I'm a staff attorney at the Network on the Harm Reduction Legal Project team. I get to moderate this panel, and I'm very excited. It's a follow-up to our conference workshop. If you were there, you'll remember we didn't get to make it to the Q&A that everybody seemed the most excited for and had lots of questions due to a fire alarm situation. And so we thought it would be best to do a brief overview, again, of what we talked about, and then give a lot of time to try and get to some of that Q&A. Prior to joining the network, I used to work in reentry, providing direct legal services to formerly incarcerated folks, working on impact litigation, and these issues being talked about are very personal for me in my own life and what I deal with. And so that informs some of the questions I might ask these panelists. A couple of disclaimers and FYIs about these presentations. Throughout the presentation, we'll be using language such as pregnant people or pregnant individuals. Not all laws use this language. Many states still use pregnant women or mothers. So with that in mind, if we slip up in our language use, it's because sometimes when you're seeing that over and over again, it gets stuck in your brain. And so we try to reverse and correct, but sometimes we also slip. So we would appreciate your patience with us if we do slip up in our language use. Another kind of FYI, the presentation on criminalization of miscarriage and abortion will have some descriptions of people's experiences. So wanted to flag that ahead of time so that you are aware that those kind of more descriptive experiences will be in the presentation. Also, as lawyers, we are lawyers. We are not your lawyers. None of this is legal advice. Please put your questions in the Q&A box. We had quite a few folks submit questions ahead of time, and we'll try and work through some of those. If we don't get to your question, either in the Q&A from the Q&A box or a question that you sent ahead of time, please follow up with us. We don't not want to answer your questions. Sometimes it's just hard to answer a more intricate question that folks like to ask on these webinars in a webinar setting. But we are always happy to answer your questions in a more in-depth response and conversation if you want to reach out to us with those questions. I think those are all my little disclaimery FYIs. And so now I'm really excited to introduce our panelists. We have Kathy Hoke, who is the director of the network's Eastern region and has been with the network since its launch in 2010. Kathy coordinates the network's Reproductive Healthcare Access Work Group and has published resources on maternal mortality, expanded scope of practice for abortion providers, Title X funding restrictions, and access to reproductive health care for people who are incarcerated. Kathy also has expertise in public health authority, tobacco, alcohol, and cannabis regulation, food security, and housing law and policy. She's a professor at the University of Maryland Carey School of Law, where she earned her JD. We'll also have Emma Kaiser, who is a staff attorney with the Network for Public Health Law's Mid-States region. Her current areas of focus include legal and policy issues related to privacy, health information sharing, and public health authority. At the network, Emma provides support in the form of research, legal technical assistance, training, and practical resources to assist those working to promote healthier communities. She holds a JD from Stanford Law School and an AB in public policy from Princeton. We also have Naisha Mercury, our newest addition to the team. We're happy to have her, who is an Equal Justice Works Fellow at the Network for Public Health Law. Naisha joined the network in May of 2025 upon graduating from Elon University School of Law. Naisha just recently published a blog post on menstrual health products for incarcerated individuals, and for the next 2 years, she'll be leveraging legal epidemiology to identify and address disparities in access to reproductive services in U.S. prisons. That was a lot of words. I'm going to pass it to Kathy, who has more words.
Awesome. Next slide. Thank you, Ashley. I just want to say, as a woman of a certain age, you know, and it's hard to find the highlights, the positives out there right now, particularly in the reproductive healthcare space. But as Ashley was, launching us, I thought, but actually, it's going to be okay because look at these phenomenal young women who are in this space with me. And so I'm going to leave at some point, and they're still going to be here doing this incredibly important work. And so I just had a moment, actually, when Ashley was talking. And so I want to thank Ashley, Emma, Naisha, Kayleen for kicking us off, but really staying true to bringing public health to reproductive healthcare access and bringing reproductive healthcare access to public health. So on that note, I'm going to talk to you about some issues associated with funding for reproductive healthcare services and some litigation issues in medication abortion. Next slide is just my kind of roadmap for you all. So in federal funding, I'm first going to explain the Hyde Amendment that you've probably heard about, and then Title X and Medicaid implications under the new administration for access to care. Then we will talk through both the litigation that's pending currently, challenging lots of issues associated with access to abortion medication. Then I'll talk a little bit about what we've heard from the Trump administration in this space. Next slide. So just to situate us with the Hyde Amendment, because again, a lot of folks have heard about this, but may not know exactly what it was. But in 1977, Congress passed the federal Hyde Amendment. It is actually an annual rider to the HHS Department of Health and Human Services appropriations bill in Congress, but it's been embedded elsewhere in the federal code. And what it specifically says is that federal dollars cannot be spent to provide abortion care. There are exceptions you can see here for rape, incest, or to save the life of the pregnant person. Then in those exception circumstances, actually coverage is required. So to the extent you can see the different federally funded or federal and state funded to some extent programs listed there in green, obviously starting first with Medicaid, the biggest one, but other folks receive care through Indian Health Services, through CHIP, the Children's Health Insurance Program, TRICARE, our military care, and even for federal employees. So all of those policies prohibit the coverage of abortion care, but it's required if it falls into one of those categories. Just so you know, politically, this was passed in response to Roe versus Wade, which became law in this country in 1972 and was obviously undone a couple of years ago by the Supreme Court in the Dobbs decision, but it persists as a part of federal law. So the thing that I want you to remember throughout all of my talk is no federal dollars are paying for abortion care unless it is in one of those exception circumstances. And just to situate you for what is the law in your states, and that is of the states that permit abortion, and I don't want to get into the characterization. That could be 30, it could be 40, but the characterization that I'm using here, about 36-ish states that actually allow, kind of real access to abortion care. 18 of those states and the District of Columbia have a similar amendment to Hyde, where they prohibit state funds from being used to provide abortion care, typically with the same exceptions as the Hyde Amendment. Some of them do permit another exception. It's not just to save the life, but for the protection of the health of the pregnant person, which is a much more expansive exception than that in Hyde. And then 18, and I use the asterisk because Pennsylvania might also fall in here. There's some current litigation over this, but 18 states permit state funding of abortion care under, like state employee programs and the like, and for pregnant people covered by Medicaid, where there is state and, federal engagement. So, that is either by a statutory or policy decision of the state, or there have been states where litigation has resulted in a court decision saying no, that care has to be funded. So just next slide, just so you know that these are legal limitations on the funding of abortion care. So what I'm talking about here when I get to the Title X family planning program is not abortion care. We are talking about the federal program passed by Congress in 1970. So it's been on the books for a really long time and has been, only modestly kind of controversial in the more recent era. It was passed as bipartisan legislation. For those of you who don't know what that means, because there is no such thing in Congress now, both parties agreed that it was an imperative that the federal government establish a program to provide access to reproductive health care for particularly for people of low income. And so Title X grants, Title X funding covers, you can see the type of services that it covers here, not abortion, but birth control counseling and services to men and women and to non-binary folks. So anyone can come in and receive birth control counseling and sometimes access to medication or IUDs or the like. Some coverage for infertility treatments that not as extensive as IVF, but other infertility services. Big one here is wellness visits in the so to see we should be seeing our gynecologist on a regular basis, and so that type of wellness, which can actually also cover lots of primary care services. It may be where pregnant people or people who are trying to become pregnant receive vaccinations because that's the comprehensive nature of that wellness visit aspect of Title X coverage. And then you can see the breast and cervical cancer screenings, the HIV and STI treatment and or screening and treatment. Those things provided obviously to people of any gender, right? And then, yes, when it comes to the pregnant person, diagnosing pregnancy, meaning pregnancy tests, as well as counseling. And I'll talk about what counseling means on the next slide. So Title X funds are available for people of low income on a sliding scale. So people who are of very low income will receive free care. And then there's a sliding scale for how much an individual would have to pay for the services based on their income. So the counseling aspect here has been relevant in the last couple of years because under the Biden administration, under the Biden administration, there was no gag rule, meaning what the first Trump administration had done was impose a restriction so Title X funds could not be used to support pregnancy counseling that educated and referred pregnant people for abortion care. Biden lifted that gag rule, and so it is allowed. And I will say the Trump administration has not affirmatively reestablished that rule. So that's what counseling means, kind of relevant to the abortion care space. Next slide, just so you can see some of the demographics of who is receiving Title X, care funded through Title X, and that's 2.8 million people in the most recent reported year of 2023. And you can see the breakdown. It's clear then that we can see that this is an issue of racial health equity. Which is and should be an imperative of everyone working in public health space, but also that it is care that is provided typically to our younger, population, right? So folks who may have aged out of being on their parents' insurance or may not have had parents with healthcare coverage. A lot of younger folks are receiving their reproductive health care through Title X funded entities. Most of the care, 60%, is provided for free because it is for people who are at that federal poverty line. And just a reminder, 0% of these funds are spent on abortion care. In fiscal year 25, Congress appropriated $286 million to fund Title X. And I say Congress appropriated because I'll talk next about whether those funds have actually all been spent. I will say that the recommendation from the Department of Health and Human Services Office of Population Health is that to fully fund Title X and realize its goals would require over $1 billion. And so at 286 million, we're doing a halfway decent job, but certainly not what is really needed to provide the care that should be covered under Title X. So what has happened already to Title X under the Trump administration? Next slide. So the first thing that happened was the freeze. So remember I said Congress appropriated $286 million, but you've heard lots about the administration not allowing funds to be used as intended by Congress. And so that happened here in this space. In April of 2025, many grantees who received the Title X funds received notice that their funding was either being terminated, frozen, they were not going to get it, or a partial freeze of their funds in what was really year 4 of their 5-year grant period. And so why did that freeze happen? Well, primarily because of potential conflicts with the president's executive order on DEI. If you want to know more about that, the network has resources about the president's executive orders, but essentially it's this umbrella that says we're not doing anything that recognizes that there is a need to address diversity, equity, and inclusion in our communities. And so, for example, one of the funded entities in through Title X in Montana indicated that their funds were partially frozen, and they were told that there were that they had statements that might be considered DEI, and that is the message on their website that says, I'm using a quote here, that they welcome patients of different identities, including teens, LGBTQ plus individuals, and survivors of sexual assault. So the administration construed that as engaging in unlawful DEI and froze funds to that particular clinic. Some of those funds have been unfrozen. It's difficult to figure out who has received all of their funding and who has not. But the bottom line is the Trump administration abused the executive power to freeze these already appropriated funds by Congress. Who that impacts? These are the type of entities that receive Title X grants: local health departments, federally qualified health centers, school-based health centers, and of course, the big boogeyman to the other side, the Planned Parenthood clinics that provide an overwhelming amount of our Title X and really important reproductive healthcare services in our communities. Obviously, this places at risk healthcare for 800,000 or more individuals. So that's what has happened. Next slide is what might happen next. So first is what could happen in the budget. We are in a government shutdown, largely because of the budget, right, and an inability of Congress to pass a budget. But just so that you know, the proposed budget that the GOP, at least at this point, seems to be behind, that was proposed by the president, includes $0 for Title X funding. So as I indicated, more than $1 billion is required to fully realize the goals of Title X. 286 million was what was for fiscal year 25, and the recommendation here is $0. That would be profoundly devastating, not just to people receiving, reproductive health care, birth control and the like, but all of it. I talked about the wellness visits, the screening for HIV and sexually transmitted infections across the population. And so the ripple effects will be devastating to communities who receive their care. And again, sometimes even vaccinations at these Title X clinics. what could happen, I don't want to put any ideas in their heads, but we do know that there's possibility of reviving the gag rule, which, if there was Title X funding, would limit the ability of Title X funded entities from counseling individuals about, the availability of abortion care and where they might receive abortion care in their community. It's entirely possible, because this has been an issue in other programs, that they prohibit Title X services to be provided to minors, kind of on the basis that interferes with parental rights to allow minors to access reproductive health care. And it doesn't talk about whether the parents are agreeing. And so it could terminate care to minors. And frankly, I just don't even know what else. So not on this slide, but I have this just in part 1 and part 2, because you can only keep your slides updated so often. And that is last weekend, as part of the reduction in force that occurred at HHS, it appears that the entire Office on Population Affairs that administers the Title X program, it's not actually in CDC, it's in HHS, was completely defunded. And so there would be no one there to administer Title X funds if there are Title X funds. It's also complicated to determine who they're saying, oops, we accidentally terminated people. It's not at all clear what that means in the Title X space. But this just in part 2 is just yesterday. A federal district court in California has determined, at least in the preliminary phase, that those reductions in force that took during a government shutdown were unlawful and cannot go forward. So who knows what's going to happen next in the Title X space. Next slide. So the other way that there is funding for reproductive healthcare access from the federal government is through Medicaid funding. And what's important here is what I call the Big Ugly Bill. People refer to it as OBA, One Beautiful Bill, or Big Beautiful Bill Act. But I'll call it the Big Ugly because that's my own, interpretation from a public health perspective. But relevant here is Section 71113 that prohibits Medicaid funding for 1 year to any provider that meets these requirements. And let me just be clear, what we're talking about is providers who are providing health care to individuals who are insured through Medicaid, billing for their services. So they're services that are covered by Medicaid, and the individual who comes in is a Medicaid recipient, and that care is provided. These entities are no longer allowed to engage in that care and receive reimbursement through Medicaid if they are a nonprofit entity that primarily provides family planning services. So Planned Parenthood and similar organizations, that they provide abortion care outside of the Hyde Amendment. So if that entity provides, not with, remember, there's no federal funding for this, but with their, otherwise they are providing abortion care, and they received in 2023 $800,000 or more in Medicaid reimbursement. Those entities are now prohibited from receiving any funding for Medicaid, regardless of whether the patient is covered by Medicaid and the care would be covered by Medicaid. This would essentially eliminate funding to Planned Parenthood and the majority of family planning clinics around the country. I have a side note in here that this, coupled with the other draconian cuts to Medicaid and imposing what we know research demonstrates completely ineffective Medicaid work requirements, will just reduce access to healthcare across the board, but with an acute impact, doubling here with the Title X impact on access to reproductive healthcare. Next slide. The good thing is lawsuits have been filed. The bad news is right now the law is in effect. And so while there had been initial challenges that the court had said, oh, we're going to, enjoin, meaning stop the federal government from enforcing this provision while this case proceeds, that actually was reversed by an appellate court that said, no, this will go into effect while the case proceeds. So right now we are under Section 71113 and its effects. But there have been challenges filed. I have here on the slide the private plaintiff piece of litigation that was filed by Planned Parenthood in Massachusetts. And they allege a variety of claims. You can see listed here. I can talk more about any of them in the Q&A if people want to know more. I don't want to dig too much into the legal nuance, but these are their claims. Added on here, however, is that also 21 states have also sued the administration, challenging Section 71113. They have some other claims that include, for example, and I think one of the most successful, and I'm going to say it in lay terms, but basically that they don't even know how to interpret and apply this provision, that it's void for vagueness, that it's not capable of being implemented. How would state A know how much an organization that met those criteria received in Medicaid reimbursements in 2023 in another state, to whether that $800,000 limit had been met, and other ambiguities in Section 71113. So we'll see where this litigation goes, but the law is in effect at this time. So the kind of stop here, on my funding conversation is it's not good. From a federal perspective, there was already minimal inadequate funding for reproductive health care for folks of low and very low income, and it's made worse surely by actions of this administration. Next slide is just a tiny focus on medication abortion litigation, because we know folks are wondering what's going on in this state. If, just to situate things, I think 1 in 5, the recent data is 1 in 5 abortions that occur in the United States occur through medication abortion. It is incredibly safe and has been demonstrated as such over the decades that it's been available for that purpose. But there has been litigation filed by several states challenging the FDA's rules associated with whether, how, and when medication abortion can be provided. And let me just make clear, this litigation is coming from abortion restrictive or prohibitive states, and most of it is because of they know that even though post-Dobbs, and their laws restricting access to abortion, that abortion care actually has not diminished. Abortions have not diminished in this country. And their perception, at least, is that medication abortion is playing a profound role in that space, and largely because it can be provided over telehealth and mailed. Unlike care that might need to be provided in person, other forms of abortion that might have to be provided in person, this can be provided from other states. That really is the kernel of what they're after here. But what they're seeking in this particular case that I have cited here is prohibition on access for minors to access abortion medication. Remember that theme of not wanting minors to receive any reproductive health care, but certainly mifepristone. I just want to throw out that they say in the complaint that it's because mifepristone significantly impacts girls' developing reproductive systems, and there's zero evidence of that. What does impact a adolescent's well-being and future reproductive health is having to carry a baby when they are very young, having to give birth to a baby when they're very young. And so access to abortion medication for minors is actually incredibly important for their well-being, contrary to the allegations. You see here the prohibition on mailing mifepristone is their critical question. They raised the Comstock Act, which is a 150-year-old law designed to basically prohibit the spread of indecent literature, i.e. pornography. I don't have time to get into the depths of the Comstock Act and its application here, but that's what they rely on for the prohibition. One of their bases for wanting prohibition on the mailing of mifepristone. And then lastly, they're asking for a return of the 2016 rules for administration or distribution of abortion medication that would allow the medication to only be used at 7 weeks or less gestation. Right now it's 10 under the current rules. That required in-person distribution, so no telehealth and mail distribution or pick up at the pharmacy without going to a healthcare, a physician, and limiting the prescribers to physicians, to MDs, and not others who are now permitted to prescribe. So the lawsuit is really riddled, frankly, with inaccurate, kind of science, and with abortion misinformation, primarily based on a retracted study, a study that had been retracted from peer-reviewed literature. Next slide, what's happening with that case? Well, the case was filed in Texas, even though Texas wasn't an original party to the litigation. Why? Because there's a very favorable federal district court in Texas to everything that is restrictive of access to abortion care. But in May of this year, the Trump administration actually filed to have the case dismissed, saying that Texas is not the right place to file this, that Texas had not been one of the states in this litigation, and so this isn't the right venue for filing. Maybe they're playing chess, I don't know. We were surprised, and the court actually then in August, to try to save this case, Texas and Florida sought to intervene. They filed a request to the judge to say, we want to be parties too in this litigation. And stunningly, I would say, color me shocked, I was very surprised that last month, the federal district court judge, who has been notoriously, oppositional to reproductive health care access, denied that intervention and transferred the case to Missouri, the first state that filed, one of the states that had filed the litigation. So it won't proceed in Texas courts. Because nothing, I could have done this just on every slide, but so that's the status of that case right now. And so it's going to take a while for anything to happen in it because it just got transferred over to the other district. But this month, or earlier this month, because it's only the 16th, but the state of Louisiana has sued the FDA in federal district court in Louisiana. They lots of the same claims, seeking lots of the same relief in this case. They do have there's a question of whether there's standing, meaning the states are the right party to bring this litigation. They have a plaintiff who alleges that her boyfriend acquired through the mail abortion medication and used that to, without her permission, cause her to have an unintended abortion. If that is true, that is horrific. And that is obviously something that we care deeply about in the public health space. But that, balancing that against people who need and want access to medication abortion is part of the question for the FDA. Bottom line is, we don't know much about that case because it was just filed. I read the complaint. It's not a complaint that I've ever kind of read before. It's not written in the way lawyers typically would write complaints, but I guess that's just the nature of litigation now. Last slide, as I'm just going to talk a little bit about, this is what the administration has done because they actually haven't done much. The FDA could take some of this action that the states have asked for without the litigation, and they haven't. And they've technically kind of defended the litigation, not substantively, but in other ways. But what are the hints out there about what they might do? Well, in May of this year, Secretary Kennedy said that he has directed the FDA to take a look at the rules, the REMS, the risk evaluation and mitigation strategies for mifepristone and see whether that they are the gold standard for treatment of miscarriage. And he indicated that any decision on this would go through President Trump. We don't know if that's accurate, actually, the first part, whether he's actually directed anyone at the agency to do that. Then in September, a bunch of attorneys general from around the country actually or I'm sorry, yes, they had complained to the FDA about medication abortion interfering with their state's abortion laws, and they received a letter from the FDA indicating that the FDA is reviewing the evidence that supports the current REMS for mifepristone. I know here in Orange that just know that while I said the FDA could change the rules, they are subject to the standards for administrative law changes. I won't get into those. So there is some basis for challenge if they were to make changes. And the last 2 points, again, this just in on this slide, September 30, which wasn't that long ago, the FDA did approve a second generic version of mifepristone. So where you put that, I don't know. And on October 9, 51 Republican senators wrote a formal request to the FDA commissioner to prohibit the use of telemedicine for administration of mifepristone because it's and just to remove mifepristone from the market because it is an imminent threat to health. So that's what's going on. But the bottom line here really is this administration really hasn't done much in the abortion medication space and are, I think, allowing things to play out in court and managing all of the other things that they're doing in this space. And on that note, I'm going to hand things over to Emma.
All right, thanks, Kathy. Hi, everyone. Thank you all for being here. I'm going to be talking about recent changes related to reproductive health privacy. Next slide, please. Slides advancing. For others? Okay, perfect. Thank you. So when we talk about reproductive health privacy, we are referring to the confidentiality of information and circumstances related to one's reproductive health. Reproductive health information is often highly sensitive, and its disclosure and use can result in a host of harmful consequences, including stigma and harassment. This information can also be used for criminalization purposes to punish providers as well as patients, parents, partners, advocacy organizations, and others that help to facilitate and support access to care. Surveillance and criminalization of pregnancy have a long history in the United States, but these threats are heightened post-Dobbs and the resultant flood of state-level abortion restrictions. The threat of these harms erects barriers to the high-quality reproductive health care to which everyone should have access. If someone believes that they will be harmed in connection with reproductive health care, then they'll be deterred from seeking it. They may also refrain from sharing full information with their providers, which can impede informed and appropriate care. And then providers may be deterred from delivering care for similar reasons. And it's important to note that the deterrent effect of criminalization occurs even under circumstances where the care in question is lawful or where there aren't really charges that can be brought. And that's because confusion about restrictions and when they apply can create gray areas, discouraging the provision of care that could implicate legal risks, particularly in environments that are hostile to reproductive rights, where decisions are closely monitored and second-guessed. These harms are disproportionately borne by structurally marginalized groups that are subject to over-surveillance and criminalized at elevated rates, many of whom are also disproportionately denied reproductive rights. These include people of color, people with disabilities, people with low or no income, people who use drugs, and trans folks, among other systemically marginalized groups. Next slide, please. So turning to legal protections for this information, I'm sure many people here are familiar with HIPAA. The HIPAA privacy rule, which was originally issued in 2000, creates protections for protected health information, or PHI, and it generally restricts the use or disclosure of PHI without an individual's authorization, unless one of the privacy rules' many exceptions applies. So in April of 2024, the U.S. Department of Health and Human Services, HHS, issued a new rule under HIPAA, the rule to support reproductive health care privacy, which arose out of increased concern post-Dobbs about the potential disclosure and misuse of reproductive health information and resultant barriers to care. I won't bury the lead here. As you might have guessed from the date span at the top of the slide, the rule to support reproductive health care privacy is no longer in effect, and I'll get into that more soon. So the new rule, what did it do? It created prohibitions on certain uses and disclosures of PHI for non-healthcare purposes. And specifically, it prohibited HIPAA-regulated entities from using or disclosing PHI to conduct a civil, criminal, or administrative investigation into, or to impose civil, criminal, or administrative liability on any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care that was lawful under the circumstances in which it was provided. I know that was a mouthful, I'll repeat it. In short, this is a purpose-based restriction that prohibits the use or disclosure of PHI for investigating or imposing liability in connection with reproductive health care provided lawfully. Next slide, please. So the rule went into effect in June 2024, and very soon after, it faced legal challenges in the courts. In federal court, there were 4 lawsuits, 2 in Texas, 1 in Missouri, and 1 in Tennessee. The most consequential case here has been Pearl v. Department of Health and Human Services, and Pearl will be the focus of much of my presentation today. So the plaintiffs in that case are Dr. Carmen Pearl, who is a family physician, and her walk-in clinic in Dumas, Texas. The plaintiffs brought 2 claims for relief, both under the Administrative Procedure Act, arguing that HHS lacked statutory authority to issue the rule, and also that the rule is arbitrary and capricious. Next slide, please. So what have we seen in terms of defense of the rule in Pearl under the new administration? In January, the Biden administration was, of course, replaced by the Trump administration, which was then placed in the position of defending the rule in the Pearl lawsuit. And Trump's HHS chose to defend the rule on procedural grounds, specifically arguing that the plaintiffs lacked standing to sue. Standing is a threshold issue requiring that all cases be based on allegations of a concrete injury that is actual or imminent. Trump's HHS expressly refrained from addressing the merits of the case, meaning that it refused to assert a position on whether or not the plaintiff's claims were valid. And while it allowed the administration to nominally defend the rule, this approach left the rule more vulnerable to the plaintiff's challenges because HHS forewent opportunities to assert opposing arguments in favor of the rule. So on January 17th, recognizing that the soon-to-be Trump administration might not zealously defend the rule, the City of Columbus, Ohio, the City of Madison, Wisconsin, and a membership organization called Doctors for America filed a motion to intervene in the lawsuit as defendants. And here the 3 proposed intervener defendants, which operate or are comprised of HIPAA-regulated healthcare providers, argued that they have an interest in the rule and also that the current parties were unlikely to defend the rule adequately. So in April, the court denied that motion to intervene, finding that the proposed interveners failed to demonstrate a sufficient legal interest and failed to demonstrate the inadequacy of the current parties, despite the fact that Trump's HHS had expressly refused to argue the merits of the case in its briefings. Next slide, please. All right, so then on June 18th, the court granted the plaintiff's motion for summary judgment, finding that the rule is invalid and vacating it in its entirety. For the sake of time, I won't get into all of the court's findings, but I'll focus on two primary ones. So first, the court found that the rule impermissibly limits state-mandated reporting of child abuse. HIPAA, as federal law and regulations, generally preempts or overrides conflicting state law, so state law that is less protective, with a few narrow exceptions. One of those exceptions is that the HIPAA statute states that it does not invalidate or limit the authority, power, or procedures established under any law, including state law, for the reporting of child abuse, among other kinds of reporting. So in other words, the privacy protections in HIPAA cannot override state authority related to reporting of child abuse. One of Dr. Pearl's arguments was that the rule violates this provision because it impedes her reporting PHI in a child abuse report to the state if that alleged child abuse involved reproductive health care. So the court agreed with this argument, despite the fact that the rule prohibits uses and disclosures of PHI for investigating or imposing liability on someone merely for seeking, obtaining, providing, or facilitating lawful reproductive health care. If the investigation or imposition of liability is for anything else, including suspected child abuse, then the rule by its own terms would not apply. In other words, the fact of suspected child abuse would mean that the PHI in question does not only relate to seeking, obtaining, or providing or facilitating lawful reproductive health care. Nonetheless, the court found in favor of the plaintiffs on this argument. The court also found that HHS acted outside of its statutory authority because the HIPAA statute, quote, did not grant HHS the power to promulgate special protections for politically favored medical procedures, unquote. The court applied an interpretive approach known as the major questions doctrine, which says that questions of major political or economic significance, which is evidently a vague standard, may not be delegated by Congress to executive agencies like HHS without clear and explicit authorization. Here, the court found that the HIPAA rule triggered the major questions doctrine because, according to the court, it regulates abortion and gender-affirming care, which are areas of great political significance, and it intrudes into an area that is the domain of the states following Dobbs. Thus, the court applied a more exacting level of review to the rule and found that HHS did not have clear congressional authority to use HIPAA in the way that it did. In this analysis, the court gave little weight to the argument that what the new rule does is not regulating abortion or gender-affirming care, but rather creating protections for private medical information, which is squarely within the authorized purpose of HIPAA. Having reached these conclusions, the court vacated the rule in its entirety, despite requests from the Trump administration that the court adopt a narrower remedy. Next slide, please. So where do things stand now? The Trump administration did not file an appeal of the decision to the Fifth Circuit. The three proposed intervener defendants did file an appeal, but they voluntarily withdrew it in September, citing resource constraints. So the rule is no longer in effect. With respect to the impact of vacating the rule, without the rule's safeguards, we'll expect to see a heightened risk of reproductive health information being used to penalize providers, patients, and others that help to support or facilitate access to services. And as I discussed earlier, these risks create barriers to vital and at times life-saving care. Next slide, please. So the past several years have seen an uptick in investigations in states with abortion bans of out-of-state providers that deliver care to patients in the abortion ban states. The rule, and also we've seen investigations of the patients themselves, as well as parents and partners and others that help to facilitate care. And the rule no longer being in effect means that there are fewer protections against demands for PHI in investigations or prosecutions of lawful care that was provided out of state. But the rule's protections were also really important for safeguarding PHI related to care provided in states with abortion bans. So if a patient seeks or a provider delivers care that is legal, notwithstanding an abortion ban, so for example, care in an emergency to save a pregnant person's life, the rules protections would give them some reassurance that information related to that care would not be collected and used against them. And this is really crucial for ensuring that potentially life-saving care is available, because patients and providers might otherwise delay or forego care in light of potential legal risks, real or perceived. There's been a devastating rise in the number of pregnant people who have died or had nearly fatal incidents because of this exact hesitancy to provide care. Vacating the rule means that there will be fewer protections against this kind of surveillance of care provided in states that are hostile to reproductive rights. Next slide, please. So that brings me to a related legal development, the co-opting of state-level abortion reporting requirements. 45 states and DC have these abortion reporting mandates. The data collected differs by state, but typically it includes the names of the medical facility and treating physician, patient demographic information, gestational duration, and the type of abortion provided. Some states collect additional information, such as the patient's reason for obtaining an abortion. These reporting requirements, which existed long before Dobbs, have at times at least aimed to serve some valuable purposes like tracking access and barriers to care. But in recent years, some states have sought to expand the use and collection and disclosure of this information to weaponize these laws as tools of surveillance for collecting information for enforcement and criminalization purposes. For example, Indiana, which has a near total abortion ban, has a law that requires healthcare providers to submit what are known as terminated pregnancy reports to the Indiana Department of Health. The Indiana Attorney General has recently pushed for the contents of these reports to be made public. According to the AG, releasing this information publicly allows anti-abortion organizations and individuals to monitor and report patients and providers to enable enforcement of Indiana's abortion ban. So in other words, the state is seeking to disclose publicly this highly sensitive, potentially identifiable information to enable a vigilante-style scheme of surveillance in the state. This law and the AG's push for disclosure have been the subject of litigation in Indiana. One such lawsuit filed in December 2024 argued that this TPR requirement violated the HIPAA rule to support reproductive healthcare privacy, but evidently that lawsuit is now moot. Next slide, please. So in a few moments, my colleague Naisha is going to discuss developments related to the criminalization of miscarriage, which involves punishing people in connection with pregnancy loss, The US has a long history of pregnancy criminalization, but research suggests that there's been an uptick since Dobbs, raising concerns about the privacy of information related to miscarriage and pregnancy loss. All states require reporting of certain fetal deaths as part of their state vital record systems. And there's some variation across states, but typically fetal deaths must be reported for a gestational duration of 20 weeks or longer. The confidentiality protections for this data also vary by state, with some states permitting disclosure to other governmental agencies. Well, to my knowledge, these fetal death reporting requirements are not currently being exploited for punitive purposes. I think that they're worth raising for attention, just given the trends that we're seeing with abortion reporting laws and the criminalization of miscarriage. Fetal death reporting laws may warrant monitoring as potential tools of surveillance in environments hostile to reproductive health. All right, next slide, please. Yep, that's all. Thank you. I'm looking forward to discussing more in Q&A, and I'll turn it over to Naisha.
Hey everyone, I'm Naisha Mercury, an Equal Justice Works Fellow here at the network, and my presentation will be on criminalizations of miscarriages. And thank you, Emma, for introducing my topic to me a little bit. Next slide, please. So about 10 to 20% of known pregnancies end in miscarriage. Abortion bans can limit care for those who are experiencing miscarriage and stillbirths. Restrictions placed on abortion threatens the quality of miscarriage care. Medical interventions used to manage pregnancy loss are often the same medicine and procedures used in abortions. For example, minestrone, which was talked about earlier, is a medication that stops pregnancy from growing and prepares the uterus to empty. And minestrone, which is taken after minestrone, causes cramps and bleeding needed to expel the pregnancy tissue from the uterus. Next slide, please. So the term fetal personhood, which is normally read about or heard about more in red states, it is a legal term that states that a fetus or embryo has the same rights and protections as a person from the moment of contraception or some other state of pregnancy. Laws that grant fetal personhood can deter pregnant people from seeking care during a pregnancy loss, because a miscarriage may be conflated with self-managed abortion, risking criminalization for pregnancy loss. Fetal homicide laws allow homicide charges to be brought for causing a pregnancy loss, and has been moving ahead in more and more red states, with some seeping into blue states as well. And what I mean by red states is more conservative states, and blue states are more liberal states. Next slide, please. So this slide focuses on the difference between abortion and miscarriages. So abortion, as you can see, is an intentional termination of pregnancy, either through medical process or by medication. It can be stigmatized or politicalized depending on the cultural and political context. Also, it is tightly regulated in many states, with laws controlling when, how, and under what circumstances they can be provided. Miscarriage, on the other hand, is an unintentional involuntary loss, often caused by natural, uncontrollable factors. It requires timely medical care to address potential health risks. Also, not generally regulated, but can be subject to investigation in certain legal environments. Although abortions and miscarriages are fundamentally different, certain states treat them similar in the context of criminalization. It is important. I also want to highlight technical terms versus technical medical terms versus legal terminology. So technical medical terms are terms that doctors use, for example, spontaneous abortions, which is for natural miscarriage, or you have induced abortion, which is for voluntary termination, versus legal terminology, which is legal terms that is used in more of a broader language, such as termination of pregnancy, which includes miscarriages, abortions, and stillbirths together in one. Next slide, please. This slide is a timeline of cases and legal responses by state that I will be discussing in this presentation that are related to criminalization of miscarriages that have happened since the overturning of Roe v. Wade. From mid-2023 to 2025, the U.S. had witnessed a troubling rise in criminal investigations and charges following miscarriages. Even though there has been prosecutions before the overturning of Roe v. Wade, these developments are Oh, I'm sorry. Yeah, these developments are rooted in ambiguous fetal personhood laws and expanded via prosecutorial overreach. One of the challenges I found while drafting this presentation was that having to find my information more from news outlets. I also want to highlight that the stories that I will be talking about are ones that have been broadcasted, not dimming the light on other miscarriages stories that have not came out yet, or that I have missed when creating this presentation. Next slide, please. This image provides a list of states, California, South Carolina, Georgia, Ohio, Oklahoma, and Arkansas, that have been investigated or involved with criminal prosecutions of miscarriages and or stillbirths up to this point in time. There has been at least 210 pregnancy-related cases documented in the year after Dobbs' decision, including 22 cases involving miscarriages or stillbirths, with 104 of them coming out of Alabama. Some states, including Oklahoma and Arkansas, have increasingly investigated and prosecuted women after miscarriages or stillbirths, often under outdated or health code laws regarding fetal remains. Both states now issue fetal death certificates as early as 12 weeks, even though they are normally issued at 12 weeks or later, but before birth. And enforcement has sometimes led to criminal charges for failing to seek care, improper disposal, or suspicion of abortion intent. Advocates argue that these prosecutions are driven by fear and stigma rather than evidence, disproportionately affecting marginalized women and violating medical norms in care. In 2023, California passed a law banning investigations and prosecutions of pregnancy loss, but prior to the law, at least 2 California women have been convicted and served time in jail and prison for stillbirths. Next slide, please. So most pregnancy losses occur in the first trimester before 13 weeks gestation. According to CDC, a stillbirth is when a fetus dies in the uterus after 20 weeks of pregnancy and is classified as early, late, or term. So early is when the loss of a fetus is between 20 to 27 weeks. Late is when it is between 28 to 36 weeks, and term is 37 weeks or more of pregnancy. Different states have different rules when it comes to classifying stillbirth. 41 states classify at 20 weeks, while Hawaii classifies at 24. Pennsylvania is at 16, and Tennessee is at 22 weeks. Next slide, please. So this slide focuses on desecration of remains, and this first instance is in 2023. An Ohio woman was arrested for suffering a miscarriage at 22 weeks in her home. Prosecutors faulted her for the way she disposed of the remains and the way she behaved after that. A grand jury declined to indict her, and the charge was dismissed a year later. Then we have another case of first, out of Ohio, they're also dating back to 2014. Another woman by the name of Rebecca from Ohio also experienced a miscarriage. In 2014 was, as you can tell, the pre-Roe v. Wade overturning. And she stated a couple of thoughts that I'm gonna put out. I thought about fishing it out of bloody water, she said. I didn't really want to hold it in my hand, but I also didn't know what I would do afterwards. And what she's referring to is her fetal remains after suffering the miscarriages. She's like, am I going to put it in the trash? Should she dig a hole in the backyard? What the hell am I supposed to do? I have no idea. But since the post-Roe era, different experiences have resulted. Next, we have a 24-year-old out of Tifton, Georgia. She was arrested on March 20th of 2025 after she miscarried at 19 weeks and allegedly placed her fetal remains in the dumpster. She faced charges of concealing of death and abandoning a body, but prosecutors dropped the case 2 weeks later when a coroner confirmed that the fetus was non-viable and had not lived independently outside the womb. Lastly, this one is a most recent case that I found, which was in July of 2025, a South Carolina woman was arrested for desecration of human remains after losing her pregnancy and placing the fetal remains in the trash. This is still an active case, so if convicted, she faces up to 10 years in prison. There are a common factor when reading the various cases. Women are being arrested for miscarrying when they most likely don't know what they are miscarrying, or they don't know that disposing of what they think is just blood would lead to criminal charges. Next slide, please. So this talks about abuse of the corpse, which is a criminal offense, generally a felony that involves intentionally treating a human corpse in a way that violates established legal and societal standards. When thinking about the term abuse of the corpse, you are thinking of people mistreating remains for medical experimentation, or you're thinking of people after a homicide dismembering the bodies, hiding them from the crime. But to see this charge being applied to miscarriage cases is crazy. And when it comes to abuse of the corpse, the definitions vary by state. For example, Ohio's abuse of the court law allows a fairly broad interpretation. It applies to fetal remains. It says that no person, except as authorized by law, shall treat a human corpse in a way that would outrage reasonably community sensibilities. Next slide, please. So these are various recommendations for what to do when experiencing a miscarriage. All of these have question marks because there's no right answer. You can self-report to authorities like the police. Should you put the remains in a plastic bag? Should you inform your physician, or should you flush the remains down the toilet? In West Virginia, a Raleigh County prosecutor by the name of Tom Truman warned West Virginians in June of 2025 that miscarriages could theoretically prompt criminal investigations under state laws governing the disposal of human remains, though he emphasized he would not personally prosecute. And as you know, as the criminal system, even though he is a prosecutor, there are also other prosecutors. So he's speaking for himself, saying he won't prosecute, but that does not speak for other prosecutors in his county. He encourages women to call law enforcement or 911 or call your doctor about their miscarriages if they didn't do anything wrong, even though it did not require it or prevent them from being charged. In some states where abortion provisions is criminalized, patients have experienced reduced willingness among some institutions and some clinicians to provide care, resulting in painful, traumatic, or even life-threatening experiences as people navigate miscarriages complications on their own. Just because some laws state that miscarriages aren't criminal doesn't mean protections are safe or widely understood. Dr. Alexandria Wells, she's an OBGYN from Seattle, Washington, recommends that her patients who are miscarrying early in pregnancy do as Rebecca did in the previous slide I talked about, and flush them down the toilet. But she did state that if you want genetic testing to diagnose what went wrong, she recommends you bringing the remains to her. Clinicians taking care of patients experiencing miscarriages have had to modify their counseling at times, withdrawing interventions. There is not much information readily available to determine what to do when experiencing the miscarriages due to different state regulations related to abortion laws, and that is part of the problem. I also want to highlight a question that was raised on how authorities like the cops or prosecutors know. And from research, I would say that I don't have an answer to that, but it can be women who have miscarried felt the need to call authorities, or their spouse felt the need to call authorities on the behalf because they simply did not know what to do. Next slide, please. So this slide focuses on ending with emotional impacts, traumatic experiences, and mental health. Suffering from a miscarriage can bring on different ranges of emotions: emptiness, sadness, loneliness, even feeling panicky. For some people, pregnancy loss can trigger mental health problems such as clinical depression and acute anxiety. And intentional termination of pregnancy even through medical process or medication. It can be stigmatized or politicalized depending on cultural and political. Oh, 1 second. We didn't even get this error. This is from a previous slide we did. The information for this slide wasn't transferred onto here. But I can look up briefly what I had. I'm sorry about that mishap. So on my end, which you guys can't see, but I will read it out. When talking about ending off on emotional impacts, in 2023, a college student, her name was Amari Marsh, was dealing with the traumatic of losing a child while also being a high achieving college student who was labeled in the news reports as a murderer. She was investigated for homicide for miscarrying a fetus in her bathroom. She thought that she was on her cycle and she actually didn't know that she was pregnant. Marsh began panicking when she realized that the police was investigating her criminally when they asked her to come in for questioning. She was arrested, jailed, and accused of homicide by child abuse before the autopsy occurred. The autopsy later revealed that the fetus died of natural causes due to an infection Marsh was unaware of. While processing an often unexpected and tragic outcome in their reproductive journeys, patients bear the additional trauma of not assessing and sometimes being actively denied evidence-based and sometimes medical necessary intervention. Many miscarrying patients are no longer shown up to hospitals anymore. Instead, they are making decisions about fetal remains on their own at home. Next slide, please. Okay, so this was the correct slide. Next slide, please. So this slide is to thank you. And as we close, I just want to leave this with you. Abortion bans don't just impact abortions. They also put people experiencing miscarriages at risk by limiting access to the same medical care. We're seeing more cases where women are criminalized simply for losing a pregnancy, adding fear and stigma to what is already a painful experience. And beyond a legal consequence, we can't forget the deep emotional and mental health toll that this has on women, as too many people are left to grieve in marriage, pregnancy loss on their own. Thank you.
Thanks, Naisha. Kayleen, can you move us to the very last slide that talks about how to contact us? As the most amount of information that folks want to leave with. Thank you all for those presentations. I'm going to rapidly get into as many questions as possible in the next 3 minutes. If our panelists can stay on and anybody wants to stay on, I think we have a little bit of time to maybe stay on a little longer, maybe not, but I'll start with everybody. What can we, either as public health practitioners, people going about everyday life, what can we do? What now? What can we do to help address what's going on? Who can we put pressure on? Are there states that are out there doing something right when the federal government's doing things terribly wrong? What can we do? And whoever wants to start, go for it.
You can jump in unless someone else wants to start. Okay, great. So I think we should likely not expect privacy protections, additional privacy protections from the federal government under this administration, but there are state, local, institutional, and individual level steps that can be taken to protect privacy. On the state level, some people mentioned this in the Q&A, but a number of states have passed what are known as shield laws, which generally prohibit cooperation with out-of-state investigations, prosecutions, or enforcement actions targeting reproductive health care. And some state shield laws include privacy protections for reproductive health information. So those of us who are in a position to do so can advocate for passage of robust shield laws that do contain privacy protections, because not all do. And in states that do have shield laws or other like state level privacy protections that encompass reproductive health information, it's really important to understand and comply with those laws. It's also important to understand and comply with federal protections that are in place, notwithstanding the Pearl decision. There were a number of questions about this in the Q&A, but yes, the HIPAA privacy rule The general protections in the privacy rule still apply, including the restrictions on disclosures to law enforcement. So it's really important to educate agencies and individuals on what those protections are and ensure that folks are complying. And then a lot, I think, will fall on organizations and institutions and individuals to take steps to protect privacy that go above and beyond what is legally required. So, for example, implementing policies and practices, like not disclosing reproductive health information for non-healthcare purposes without an individual's consent unless you're required to do so by law. So those are just some examples, I think, especially in states without shield laws or other like robust privacy protections. A lot will fall on organizations and individuals to do these sort of like take these supplemental steps to protect privacy.
Go ahead, Naisha.
Briefly, I would say, just like I stated in the slides, as far as my presentation, there's no right answer. There's no answer at all, especially now that abortion bans is state regulated. There are red states and blue states doing at this point what they feel is best for their state. And since now that miscarriage care is being affected because of abortion laws, I actually do not have an answer for that. But one thing I would say is probably consult with your physician first. If you want somebody trusted who you can call first, I would reach out to your physician.
I'll just add that, I already took up too much time, so I don't take the time here, but support your abortion funds. There's lots of nonprofit organizations that are helping to provide abortion care to people. And so do that. And I think from a public health perspective, so government folks or folks working with health professionals, it is making sure they understand what the law actually is now, because I think a lot of this litigation and threats of what's going to happen makes healthcare professionals reasonably, scared to engage in some of the healthcare that they would otherwise be engaging in. And so making sure that they understand what your state's rules are and what they are permitted to do under the current, for example, FDA REMS for medication abortion, because it can be really confusing and scary to be a healthcare provider in this space with so much challenge going on, and not having the time to listen to this webinar because they're helping their patients.
Thanks, Kathy. I'm going to go ahead and ask maybe one last question, but I'm going to aim it at Emma because there's still some questions in this Q&A chat and some questions that we had coming in ahead of time. A lot around heightened surveillance and reporting and things like that. I know you said after, I guess like for like a concrete example, you mentioned in the Pearl decision, they used mandated child abuse reporting. Can you say more about kind of that and just like reporting and surveillance generally, and how it fits into the state's approaches to restricting reproductive rights, and what are we doing? What can we do?
Yeah, no, that's a great question. So amidst the rise in fetal personhood claims that Naisha was talking about that treat people as having the right, or excuse me, treat fetuses as having the rights of people, child abuse, endangerment, and neglect charges provide a vehicle for punishing people for abortion, miscarriage, or other conduct during pregnancy. This is an especially common means of punishing people who use drugs during pregnancy, who've been the subject of pregnancy criminalization for many decades. And the plaintiff's argument and the decision in Pearl, I think, signals a push to treat reproductive health care as child abuse, even under circumstances where it is provided lawfully. And this includes, like, through a fetal personhood lens, construing abortion as child abuse because it harms the fetus by terminating the pregnancy, and then also construing reproductive health care provided to a minor as child abuse because that reproductive health care is seen as inherently harmful. There's a new report out from the organization Pregnancy Justice that highlights the role of the healthcare field in facilitating these charges. The report found that in over half of cases, recent cases of pregnancy criminalization charges, they involve disclosures of information from healthcare settings to law enforcement. And this is in part due to mandatory reporting laws that require healthcare providers to report certain incidents, such as substance use during pregnancy, but also this happens in part just due to voluntary reporting that's caused by confusion, fear, and also bias against the people who are reported. I'll note that the rule to support reproductive healthcare privacy was by no means a panacea when it comes to preventing against that kind of reporting, because the rule only protected against disclosures that were investigating someone for obtaining lawful reproductive healthcare. So if someone was being investigated for something else, for example, suspected child abuse for using drugs during pregnancy, that information related to that would not be protected from use or disclosure under the new rule. So that's all to say that even if the rules protections were still in place, we would still need more robust confidentiality protections and dismantling of mandatory reporting laws in order to protect confidentiality, particularly for pregnant people who are accused of child abuse, mostly in the context of pregnant people who use drugs.
Thanks, Emma. Do we have time for one more? Do we think? I don't see any shaking of heads, no. So I guess last one kind of for all of you, since, I mean, mostly Kathy, maybe because you talk to students, but I think for Emma and Naisha, as people who also sometimes talk to students and young people, and not even just with students and young people, how messaging and phrasing and how we talk about this and disseminate this information to people, what do you all recommend?
Sure. So, I mean, for me, I teach law students, and what I've learned, because again, I'm a woman of a certain age, right, is that they actually don't know the history behind, everything about reproductive health care in this country. And so I actually think it's really important that we remind people of where we've come from. And I have a "We Won't Go Back" sticker here, in my office. And I think that it's really important, really across issues that we're dealing with right now with this administration in the public health space, but that we educate young people about where we came and how we got here, so that they can really understand the impacts of the potential changes, or some of the changes and the potential changes that are happening, and that we actually treat them as people who can and will make a difference moving forward. Like I said, I'm just excited to be on with the young people here today, because they're going to carry this, and so we have to trust that they are going to do the job, but we have to invest in them so that they can. So to me, it is giving them the background that they need to really understand what's happening today, and giving them the confidence that their voice matters, and that they should use it.
I can briefly go. I agree with you 100%, Kathy. And as a new attorney coming in to the field of law and reproductive health, I just feel like this is, I won't even say a minor setback, it's a major setback, but we're going to have a major comeback. I know it just seems like there's a lot going on within the public health law space. And as far as reproductive rights, we as lawyers don't even know where the future's headed, but we're just trying to advocate, put out more resources for people. So my advice to the younger folks listening is just start doing your research, start seeing what you can find, discrepancies, gaps that's been happening. And we're every day just trying to put stuff out to continue on the update with what's going on with the current administration. How is it affecting public health? How is it affecting the reproductive health space? So yeah, that is my piece of advice, is just research, read, try to keep up to date with what's going on, even though it's hard to do that, because you may wake up in the morning and find something new. So
All right, I know we are very much out of time. I'm so sorry. Thank you all for staying on with us a little bit longer. If your question didn't get answered, please email us, fill out our technical assistance form. If you're not sure who to email one of us and we will reroute it to the right person. If you send us an email, we will get to your, even if you think it's a small question, it's not a small question. If you had the question, it came to you and you want the answer. So please send us an email. I know that there's a lot that were like very technical in there, so definitely send us an email. Or just reach out to our form. Thank you so much to our panelists. Thank you to everybody who came. Thank you for staying late. That's all I got. Thanks, y'all.